If you store food at home in America, everything you thought you knew about your rights was changed. A federal appeals court dropped a landmark ruling this April that is rewriting food stockpile laws across the country in ways that almost nobody in the mainstream press has explained clearly to ordinary citizens. There are 10 massive changes in this decision, and some of them are going to shock you. These changes hand you new legal protections while simultaneously creating compliance traps you never saw coming, traps that could result in government inspections, fines, or seizure of supplies you spent years building. Hit subscribe right now because missing this could cost you everything you have worked to prepare. Here are the 10 changes every citizen who stores food, grows their own produce, collects rainwater, or maintains emergency supplies needs to understand immediately. Some of these rulings expand your rights in ways preppers and homesteaders have been fighting for decades. Others close loopholes that state and local governments were exploiting to crack down on self-sufficient households. All 10 of them are in effect right now, and the gap between knowing about them and not knowing about them is the difference between a protected household and a targeted one. The first change is the foundation that makes everything else in this ruling possible, and it completely flips the legal framework under which government agencies at the federal, state, and local level have been regulating food storage for ordinary citizens. For decades, courts allowed regulatory agencies to pass restrictions on home food stockpiling, rainwater collection, home gardening, and emergency supply storage without requiring those agencies to prove their regulations were genuinely necessary. The burden of proof sat entirely on the citizen challenging the rule, not on the government imposing it. That framework just ended. The April ruling establishes that regulations targeting a citizen's right to store food and maintain emergency supplies for their household must now pass what legal scholars call strict scrutiny, the most demanding legal standard that exists in American constitutional law. Under strict scrutiny, anytime a government agency wants to restrict your ability to store food, maintain emergency water supplies, or prepare for disaster scenarios, that agency must demonstrate a genuinely compelling government interest, prove that the regulation is narrowly tailored to serve that interest, and show that no less restrictive means exist to achieve the same goal. The government now carries the full burden of justifying every food storage regulation it wants to enforce. That shift puts thousands of local ordinances, HOA rules backed by municipal code, and state agency guidelines in serious legal jeopardy. And it is the legal foundation on which every other change in this ruling rests. The second change could save ordinary citizens from financial ruin if they are ever subjected to a wrongful government inspection or seizure related to their food storage. People whose homes were raided by agricultural inspectors, health department officials, or local code enforcement over food storage complaints had virtually no legal recourse even when those raids were conducted without proper justification. The legal costs of fighting back were enormous. The burden of proof was stacked against the homeowner, and government agencies operated with near total immunity for the damage they caused. The April ruling creates a meaningful civil liability shield for citizens whose food storage rights are violated through unlawful government action. If a government agency conducts an inspection or seizure of your food supplies without proper legal basis, the burden now shifts entirely onto that agency to prove their action was justified before any civil proceeding against you can proceed. Real cases have already established the pattern this ruling addresses. A family in rural Oregon had 3 months of emergency food supplies confiscated by county health officials acting on a neighbor's complaint with no criminal charges filed and no compensation provided for the destroyed inventory. A homesteader in Idaho faced $40,000 in legal fees fighting an agricultural department inspection that found nothing unlawful. The new civil liability framework means that the agencies responsible for those kinds of actions now face direct financial accountability, and citizens who were wronged have a viable legal path to recover what was taken from them. The third change creates the most direct and personal accountability for government officials that the food storage rights community has ever seen, and it directly addresses the qualified immunity doctrine that has protected inspectors and agents from personal responsibility, even when their actions clearly violated citizens' rights. For decades, health department inspectors, agricultural officials, and code enforcement officers could raid your home food storage, seize your supplies, destroy your inventory, and face zero personal consequences, even when courts later determined their actions were unlawful. The shield of qualified immunity made personal accountability for government officials essentially theoretical. That shield has now been eliminated for clearly established food storage rights violations. Under the April ruling, government inspectors and officials who violate your documented right to maintain food storage who seize supplies without probable cause, who conduct inspections without proper warrant or consent, who destroy inventory without legal authority now face personal civil liability for their actions. A case from just last month illustrates exactly why this matters. A county inspector in a Midwestern state entered a family's property and confiscated over $8,000 worth of canned and dried food storage based on an anonymous tip without a warrant and without finding any actual violation. Under the old framework, that inspector faced no personal consequences. Under the April ruling's new accountability standard, that inspector and the agency they represent are now exposed to a personal judgment. This creates the kind of real accountability that actually changes behavior, not just at the individual inspector level, but at the agency policy level, where decisions about how aggressively to pursue food storage compliance cases are made. The fourth change shuts down what had become one of the most commonly used government strategies for restricting citizens' ability to maintain meaningful food storage. The designation of virtually any residential space as subject to special storage restrictions based on zoning, municipal code, or health department classification. States like California, New York, and Illinois developed extensive frameworks for designating residential properties as subject to food storage limitations based on location classifications, urban residential zones, properties near waterways, homes within certain distances of commercial food operations. All of these designations were being used to justify restrictions on how much food a household could legally store and under what conditions. The April ruling establishes a strict two-part test for what actually qualifies as a legitimate basis for residential food storage restrictions. A restriction tied to a documented public health risk with specific evidentiary support qualifies. A restriction tied to a genuine safety hazard with independently verifiable data qualifies. But a restriction based solely on zoning classification, neighborhood designation, or the general preference of a municipal authority for limiting what residents keep in their own homes does not qualify under the new standard. Local governments across the country are now being required to strip back the majority of their residential food storage restriction frameworks because they cannot meet the evidentiary standard the ruling demands. Citizens who were previously told their food storage was non-compliant based on nothing more than a zoning designation now have the legal standing to challenge those determinations directly. The fifth change ends what had become a bureaucratic weapon wielded against homesteaders, home gardeners, and citizens who produce their own food, the strategy of simply sitting on permit applications indefinitely until applicants gave up and stopped pursuing legal recognition for their home food production activities. Anyone who has tried to get a cottage food permit, a home garden license in a restricted municipality, a backyard chicken permit, or any other form of official recognition for home food production knows exactly how this worked. You submitted your application. The months passed, you called and were told it was under review. More months passed, a year went by, the message was clear, even if it was never stated directly. The system would make compliance so exhausting and so time-consuming that most people would either give up or simply operate without the permit and remain permanently vulnerable to enforcement action. The April ruling mandates that government agencies must now approve or deny any permit application related to home food production, food storage systems, rainwater collection, or residential agricultural activity within 60 days of receiving the complete application. If the agency fails to respond within that 60-day window, the permit is automatically approved by default. Agencies cannot request additional documentation after a complete application is submitted unless they identify a specific legal deficiency in writing within the first 30 days. Several municipalities are already reporting that they have processed more home food production permits in the weeks since this ruling than they did in the previous year combined, because the consequences of delay are now reversed entirely. The delay that used to benefit the bureaucracy now benefits the citizen. The sixth change eliminates one of the most direct and invasive forms of food storage restriction that had been quietly spreading through municipal and county codes across the country. Explicit limits on how much food a private household is legally permitted to store in their own home. This is not a hypothetical concern. Multiple jurisdictions develop specific ordinances capping the amount of stored food, water, or emergency supplies a household could maintain, typically justified through fire codes, health codes, or emergency management frameworks that were stretched far beyond their original intent to reach into people's pantries and storage rooms. Some of these limits were genuinely astonishing in their specificity and their invasiveness, A county in one western state had ordinance language limiting residential food storage to a 30-day supply, with the stated justification that larger stockpiles created fire hazards and attracted pests. The municipality in the Northeast applied commercial food storage regulations to private homes above a certain square footage, effectively requiring residential inspections of food supplies. The April ruling addresses this category of restriction directly and definitively. The government cannot dictate to a private citizen how much food they choose to store in their own home for their own household's consumption and emergency preparedness. Storage quantity limits applied to private residences without specific documented individualized evidence of actual hazard violate the legal standard the ruling establishes. These ordinances are now unenforceable, and citizens who were previously cited or fined under them have legal grounds to seek remediation. The seventh change is the one that is generating the most controversy in government circles, and for good reason, because it exposes and orders the elimination of food storage tracking and registry programs that most citizens had no idea existed. Federal law has long prohibited the government from maintaining national registries of certain types of private property, but several states and localities developed what amount to de facto food storage registries through a combination of permit requirements, inspection records, utility monitoring data, and agricultural reporting systems that collectively created detailed pictures of which households maintained significant food storage and exactly what those supplies consisted of. California's agricultural reporting system contained data linking residential properties to home garden outputs and food preservation activities going back years. Several counties in the Pacific Northwest maintained inspection records from cottage food permit reviews that functioned as inventories of household food storage capabilities. The April ruling calls this category of tracking out directly and orders these systems dismantled. Any state or local database that tracks individual households' food storage quantities, types, or emergency supply capabilities as a general surveillance matter, rather than in response to a specific documented complaint with legal basis, violates citizens' rights and must be eliminated within 180 days of the ruling. States maintaining these systems are required to notify affected households that their information has been permanently deleted. Several states are challenging this requirement, but the court made clear that non-compliance will result in contempt proceedings and daily financial penalties until the registries are gone. The eighth change directly addresses the way regulatory agencies have used cottage food licensing and home food production permitting as tools to suppress rather than legitimately regulate home-based food activities. For years, the agencies responsible for overseeing cottage food operations used the licensing process as a weapon, showing up for inspections with checklists designed to find technical violations in the paperwork requirements rather than actual public health issues, then using those technical violations to revoke licenses, impose fines, and shut down legitimate home food operations that pose zero risk to anyone. The documented cases are remarkable in their pettiness and their consequences for real families. A home baker in a southern state lost her cottage food license because she listed her production square footage as 180 square feet rather than 185. A jam and preserve producer in a Midwestern state had her license revoked because she used the wrong font size on a single batch label. A home canning operation that had operated legally for 7 years was shut down because an inspector determined the record-keeping format did not precisely match the current year's updated template. The April ruling establishes clearly that a cottage food license or home food production permit can only be revoked if the holder commits an actual food safety violation that creates a documented public health risk, not administrative errors, not technical paperwork discrepancies, not formatting issues on records. Agencies must issue a written warning and provide reasonable time to correct honest administrative mistakes before any adverse licensing action can be taken. This levels the playing field for the millions of Americans who generate meaningful household income and food security through cottage food operations. The ninth change addresses one of the most legally inconsistent and practically frustrating areas of food self-sufficiency law in America: the patchwork of state and local restrictions on rainwater collection that left citizens in many parts of the country technically in violation of law for collecting water that fell on their own property. The situation that existed before this ruling was genuinely absurd in many jurisdictions. States like Colorado had long-standing restrictions on residential rainwater collection that were rooted in century-old water rights frameworks designed for large-scale agricultural water allocation, frameworks that were never intended to apply to a homeowner putting a barrel under a downspout to water a garden. But those frameworks were being applied exactly that way, and citizens who collected rainwater for home garden irrigation, emergency water reserves, or household cleaning uses faced real legal exposure in multiple states. The April ruling establishes a national baseline protecting citizens' right to collect and use rainwater that falls on their own property for their own household purposes. States can still maintain reasonable water rights frameworks for large-scale collection and commercial agricultural use. What they can no longer do is apply those frameworks to individual households collecting reasonable quantities of rainwater for personal use, gardening, and emergency preparedness. The ruling specifically protects residential rainwater collection systems up to a defined capacity threshold, prohibits fines and penalties for collection below that threshold, and requires states with existing criminal or civil penalties for residential rainwater collection to eliminate those penalties within 90 days or face legal challenge under the ruling's framework. The 10th and final change makes one of the most practically impactful improvements to the daily reality of food self-sufficiency in America, dramatically simplifying the legal framework for transporting home-produced food, preserved goods, and emergency supplies across state lines. For years, citizens who traveled between states with home-canned goods, homegrown produce, home-preserved meats, or even commercially purchased emergency food supplies faced a confusing and constantly shifting patchwork of state agricultural inspection requirements, produce import restrictions, and food transport regulations. People were cited at state agricultural inspection stations for transporting their own home canned goods. Families moving between states with large food storage supplies faced questions, and in some cases, confiscation at state borders. The legal landscape was so inconsistent and so poorly communicated that even well-intentioned citizens had no reliable way to know whether what they were doing was legal. The April ruling establishes a national baseline for recognizing the right of citizens to transport home-produced food and personal emergency food supplies across state lines for personal household use. States cannot impose additional inspection requirements, documentation demands, or quantity restrictions on citizens transporting personal food supplies that were legally produced and legally possessed in their state of origin. Your home canned goods, your emergency food storage, your homegrown and preserved harvest, all of it travels with you legally across state lines under the new standard without requiring you to navigate 50 different sets of agricultural transport regulations before loading your vehicle. Here is what every citizen needs to take away from everything covered in this video. The April ruling is a significant expansion of the legal protections available to people who take their household food security seriously. But those protections only work for you if you know about them. Verify your specific state's response to this ruling through your state attorney general's official website. Document your food storage activities, your permits, and your production practices so that if any government agency ever questions you, your compliance record speaks for itself. If you receive any inspection notice, permit denial, or agency communication related to food storage or home food production, do not handle it alone. Consult with an attorney who understands this ruling and how it applies in your specific state, and understand that the legal challenges to this ruling are already filed. Several states are pushing back aggressively. The full legal picture will continue to evolve over the next 12 to 18 months. Staying informed is not optional. It is the most important thing you can do right now to protect what you have built. Share this with every person you know who takes their household preparedness seriously. Subscribe so you hear about every development in this legal landscape before it affects your situation. Drop your state and your specific question in the comments because your situation could become the basis of the next video. I will see you there.